Trademarks in Canada serve as identifiers of the source of goods or services, helping consumers distinguish between different producers and ensure the quality and reputation of products. Considering the scope, in Canada covers a wide range of signs, including words, designers, dates, textures, moving images, modes of packaging, holograms, sounds, scents, three-dimensional shapes, and colors. The protection is valid for 10 years and can be renewed indefinitely as long as the trademark is still in use. Which are the benefits of trademark holders in Canada? Trademark registration grants holders exclusive rights to use the mark across Canada, provides proof of ownership and legal title to the trademark, enables the holder to take legal action against unauthorized use, enhances brand identity and consumers' trust, and also establishes the brand as the legitimate source of products or services. It also allows for licensing the trademark to other businesses, generating some revenue, and facilitates obtaining protections in foreign countries through the Madrid Protocol. On the other hand, trademark protections has some limitations. Trademarks cannot protect features essential to an article use or purpose. Protection is limited to Canada and does not extend internationally unless registered in other jurisdictions. Others may descriptively use the trade without infringement, and trademark rights may not extend to goods imported from other countries. And lastly, extended non use of the trademark can lead to abandonment and loss of protection.
Okay, so now we'll quickly move on to understanding what patents are. So, patents are generally the rights that's given to the inventor of a product or a service, which is backed by legal means, and they are given an exclusive rights when it comes towards that product or service that they're selling, distributing, and using for a certain period of time. So, we have the time period for various types of patents, and the types of patents will be discussed in the next slide. But then, just for an overview, the time period for utility patents is 20 years, the time period for plant patents is 20 years, and the time payment for design patents is 15 years. We'll move on to understanding what each of these patents are, like I said. But then there's one condition about obtaining a patent. So when you obtain the patent, it is eventually going to be on the market once the time period expires. So anyone can use it. And the limitations are, like I said, there's an expiry period to it. Its compulsory requirement is to obtain a license. So now we move on to quickly understanding what the types of patents are. So followed by utility patents, these are generally providing a coverage towards the advancements of the technologies that an inventor makes or comes up with. Design patents are mostly concerned with the artistic values of a product or a service that is being designed by the inventor. And plant patents is where an inventor comes up with an invention of producing a new variety of plant through a combination of certain different plants.
Hello everyone. Now I will talk about the copyright. But what is the definition of copyright? Copyrights under the Act, copyright is the legal protection granted to creators of original works. It gives them exclusive rights to reproduce their work, publish or distribute copies, perform their work publicly, and adapt or modify their work. In the next slide, I will explain in more details about that. Now I will focus in four important sections. The first one is copyright protections, the rights of creators, extent of protection, and notable exceptions. The first one is copyright applies to original literary, dramatic, musical, and artistic works that are fixed in a material form, such as writing or recorder. This protection is automatic upon creation, but registration with the Canadian Intellectual Property Office (CIPO) provides a certificate that can serve as legal evidence that this protection also it's for the last for the creator lifetime, but additional 70 years more after the creator date. In the section of right of creator, here in Canada, creators have two types of rights: economic right and moral right. The economic right it include the right to reproduce, publish, perform, or adapt their work. In the second one, in the moral right, this ensure that creators' works it's not distorted and allow them to be credited, or if the creator one could be anonymous or pseudonymous if they want. And the third point in the third section, it's about extent of protection. A copyright cover a wide range of works, including books, software, films, music, and architectural designs. Works enter in the public domain after the copyright term expires. And then of this time, this is a public domain. And the last one, with notable exception, the Copyright Act include exception to balance creator rights with the public access. We talk focusing the this exception could be the fair dealing, uh, allows to the other people no allows limited use of copyright works for purpose like research, private study, criticisms, review, news reporting, education, and also parody. Uh, this exception permits a copy for educational purpose under specific conditions. And also the libraries, archives, or museums are enabled to make copies for preservation or research on other those. Thank you.
Hi, I'm Drasti, and I'll be talking about industrial designs in Canada, why they matter, what they are, how they work. Industry designs protects the visual appearance of products like their shape, patterns, and decorations. This means companies can legally prevent others from copying the unique look of their products. But why does this matter? Industrial design protection helps businesses stand out, encourage innovation and creativity, and prevents imitation. This is especially important for industries like fashion, furniture, and tech, where unique product designs attract customers. By securing an industrial design, businesses can maintain a competitive advantage and safeguard their creativity. However, it's important to note that industrial design protection does not cover how a product functions, only its aesthetics. Once registered, the protection lasts for up to 15 years, 10 years plus 5 years of renewal, giving businesses an edge in the market. While industrial design's protection offers great benefits, there are some limitations as well. First, protection is not automatic, it must be registered. Also, it only covers design, not its functionality, as I mentioned earlier. And finally, the design must be new and original, it cannot be something already published or widely used. So, in conclusion, industrial designs play a key role in protecting visual innovations in Canada. They provide legal security to businesses while promoting originality in product development. Thank you.
Thank you, Drashti, for explaining your topic. I'm Maflik here, going to explain what is trade secret. First of all, I'm going to explain the definition of what is trade secret. It is confidentiality of business information that gives you competitive advantages. For example, for Coca-Cola company, their recipe is um, the exact secret of their company's success. So, Coca-Cola's recipe is considered as their trade secret. And legal protection. The next is legal protection in Canada, covered under a common law and contractual agreement. Example: NDAs and confidentiality clause. It helps in keeps the secret very safe. So this is a legal law which has been followed, and remedies for infringement. Infringement is if something has been stolen, or if someone has been taken your information, you can file a lawsuit, or you can stop the misuse, or you can take legal action against whoever is misusing your information. It basically says that, what happens if it is being stolen. You can ask the court to stop the misuse and take the action, and you can sue them for monetary damages. The key takeaways here is protecting the trade secret is cruel for the business, and securing valuable information. Keeping the trade secret safe and helps the business to stay in the competitive product and valuable information. Conclude: intellectual property safeguarding, creating of the mind is vital for innovation, creativity, and economic growth. Balancing protection with the need of public access and protection. It means that when you have something, when you have your recipe, or when you have something for the secret for yourself, you have to, for the company, you have to keep maintain it as very safe, and it is also very essence for the company's profitability to be managed in the future as well. uh, Basically, it says that it should be publicly accessible, whatever is being done in the company, but the right recipe should be kept it as secret, so there is a healthy environment in the organization for the public as well, and the competitors as well in the market. Thank you.